All right, so what do attorneys do with this information? Jonna Spilbor is with us this morning to talk more about the case, the evidence, and Kohberger won't be back in court until June for a preliminary hearing. Good to see you this morning. Thank you. By the way, Jonna is a criminal defense attorney, lots of research on the death penalty, which Idaho does have. So let's talk about these posts. They date back more than a decade or so. If he did, in fact, write them, can it be used against him in court?
So it's a little too soon to tell. What we generally classify this type of information as is character evidence. And while we are a very curious world, and it's interesting to us because we want to know as a society, what kind of person is capable of committing this horrific quadruple murder. But from an evidentiary standpoint, at this point in time, it probably has little value. And I say that for a couple of reasons. Number one, character evidence in general usually can't come in and be used against somebody just to prove their propensity to commit a crime unless it shows something else like motive, common scheme, etc. And what we know so far about Bryan Kohberger is he has no criminal history. And number two, the fact that he was a depressed teenager, you know, a lot of people are depressed, a lot of people suffer from anxiety, and that doesn't make them a murderer. So at this stage, it's more interesting because it satisfies our curiosity and has a very little evidentiary value yet.
The other thing to point out here, Idaho does not allow an insanity plea. Why is that important?
You know, I think that's huge because number one, Bryan Kohberger is not going to be able to plead not guilty by reason of insanity, but it may help him. So let's fast forward and read the tea leaves. Let's say Bryan Kohberger had some sort of break with reality. Let's say he had untreated mental illness and it led to him committing these crimes. And we are so far away from that, but we're hypothesizing. Well, what this information may do is offer what we call mitigation. And why is that important? Because mitigation may actually save Bryan Kohberger's life if he were found guilty and there was a jury who wanted to have him put to death as his punishment. This type of information may come in and persuade the jury to not, or the trier of fact to not institute the death penalty against him, but give him, you know, life without the possibility of parole, if in fact he's found guilty.
Right. A lot of ifs here. The when we know, which is not until June, will we see this preliminary hearing? Who benefits more, the defense or the prosecution, in having so much extra time to prepare?
I have been scratching my head for 4 days trying to figure out why the defense would give the prosecution 6 months to essentially help build their case. It is so unusual. I have a couple of theories on opposite ends of the spectrum. Number one is perhaps Bryan Kohberger has said to his defense team, I am not guilty, but proving me not guilty or finding me not guilty is not enough. I need to be exonerated so that after this trial, I can go have a life. Because right now, I mean, think about it. If Bryan Kohberger was just found not guilty and he goes to apply to some corporation as a salesperson, he's never going to get a job, like never. So he might be saying, take all the time you need to find out who really did this. On the other end of the spectrum, he could have said, yeah, I am guilty. And now it's your job to save my life. So get all my medical records, get my entire mental history, and we're going to go at this to try to mitigate and not have the death penalty on the table at all. Those are two diverse hypotheses. And again, just hypotheses. But I'm trying to figure out, Marni, why the defense gave the prosecution this much time when we know the prosecution doesn't have all the puzzle pieces.
Right. No, this is going to be a mini trial, as it has been described. I'm wondering if the surviving roommate who witnessed the killer that night that the murders took place will be called to the stand in the pretrial or in a trial if it so happens. What do you think?
I'd bet my bottom dollar on it. I bet you absolutely, because that's a very curious piece of evidence. You know, when we look back, why didn't she call 911? Why did she lock the door and go to sleep? What else did she see? Why? It's an odd piece of evidence, and it's going to be challenged. I'm not personally challenged her. I believe her. But as a defense attorney, you have to challenge that evidence. And I'm sure the defense team will. And that will mean calling her to the stand and grilling her on what exactly happened and what she remembers.
Right, and having her look him in the eyes. She described bushy eyebrows with a black mask walking through a dark hallway. Scary stuff.
Right.
All right, criminal defense attorney Jonna Spilbor, thanks for your perspective as always. We'll see you again soon. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.